Thanks for coming. I'm Robin. I'm the founder of Pretzel Kids, and I'm here with Michael Hayes from Counsel. And I'm going to turn it over to Michael. He'll tell you a little bit about him and then launch into our workshop today.
Yeah, hi everyone. It's a pleasure to be here with you today. As Robin mentioned, my name is Michael Hayes, and I'm the head education specialist here at Counsel. So, part of my job and what I love doing is connecting with our community and kind of helping everyone understand kind of the legal landscape, specific in these specific industries, that we work in. We really specialize, working with health and wellness, entrepreneurs, specifically in yoga, a lot of Pilates, health coaching, that type of a thing. So it's one of my favorite parts of my job is being able to, again, connect with our community and just kind of be a source of information and education. So, that's really the goal, here today. Specifically, we'll be talking about, being prepared for 2024. What do you need to be legally protected in the new year? And, more specifically, we'll be speaking about a few, really critical, foundational, legal agreements, legal documents that are, really important to have in place just to make sure that you have, all of your bases covered and, can feel confident, in your business, knowing that you're protected and, not have any of those, late nights up, sleepless nights, worrying about, any potential legal issues. So, while some businesses, are more complex, than others, all businesses have, legal needs, and especially those that are facilitating, movement, such as, yoga classes, because they just come with an inherent degree of liability, right? When you're facilitating, physical movement, exercise, of any kind. And a lot of these legal issues are kind of invisible, so to speak. But the liability and the duty of care, it really all boils down to the duty of care. And these are legal principles. And what the duty of care means is that when somebody is under your guidance, you have a level of care that you need to meet, in providing your services and in advising them and in, facilitating, their activites, under your supervision. And, in the event that something happened, that want to make sure that you have, that their claim can't claim that you violated your duty of care, right? In terms of the services that you've provided, to them. That would really be kind of the legal theory that somebody could use to, to pursue a claim, against you in the event that they had, any type of injury or detrimental, impact, from working with you or from participating in activities that you supervised. So really our goal, again, my goal here today is to really just kind of raise awareness and, educate, yoga professionals on what they need in a very practical sense, as simple as possible. And the law can get very complex, very quickly. So really one of the primary goals is just to simplify things. And that's one of our core principles at Conscious Counsel is simplicity and, just kind of in the way we approach, the law, and also kind of in how we prepare and draft documents, it's making sure that everyone understands what's written. Because, even as a lawyer, when I read a lot of contracts, my eyes just, glaze over, and, you're not really understanding what's written in the document. You can have a great agreement in place that technically covers everything, but if people don't understand the terminology that's being used, you still leave open room for misinterpretations, and then you can still have issues, down the road. So we really feel that, simplicity is key. So it's another goal of mine is to be able to present this information in a way that is as simple as possible. So hopefully I'm able to do that. Obviously in your business, when everything is going great, the need for legal documents is less important, right? And but it's kind of like wearing your seatbelt, right? Like you only need it when you need it, and a lot of the times it's in place, and yeah, technically you didn't need it, on particular, trip, but in the event you ever do need it, you're really glad that you have it. So that's kind of analogy that we use, because nobody plans accidents, right? And if you have and nobody plans legal issues for their business, of course. These are things that are typically unforeseen and can kind of crop up rather quickly and unanticipated. So you want to make sure that you have the right protections in place, in the event that something does occur. So we've now, because the thing with legal issues is they are always more expensive and more complicated to solve after the fact, right? So preventative measures that you can put into place are always faster, easier, less headaches, and less expensive than trying to correct or fix these same issues, after the fact. So it really is about mitigating risk, limiting risk to the maximum degree possible, and avoiding issues before they come up. And the time and resources that you invest into that will pay dividends in the event that anything does happen, because again, all that would be multiplied after the fact in terms of cleaning up a mess after it's already happened. So at this point, we've been doing this for a little over 6 years. We've worked with over 1,000 clients, in the health and wellness space, primarily again focusing in yoga and Pilates. So we've seen a lot of things go wrong. Various injuries that clients may suffer. Privacy and information collecting is a big one that when you talk about the invisible issues, it's something that, a lot of times it's very easy to forget about, right? If you're collecting any type of personal information, I'll go into this in more detail when I cover the specific type of foundational documents that I referred to earlier. But it's one of those that in today's digital age, if you're collecting any type of personal information through your website, processing payments online, anything like that, that hacking is a big issue these days. And your client's personal information that you collect can be at risk. So again, one of those kind of invisible legal issues that you want to make sure that you have the right safeguards, in place. So, again, a lot of things can happen. They're usually unanticipated, unexpected, occurrences. But the fix for all of this is having the right legal documents in place. So again, preparation is critical on the front end to minimize the damage and the headaches that are caused, in the event that any issue arises. So before I explain what these documents are and kind of what the purpose of each of them is, I just kind of want to briefly explain how the system works, how the legal system works. Like if you have an issue, you have a problem, how it's likely to play out, like what's going to happen. And obviously, if there's no issues, then there's no problems, right? But if there is an issue, the first thing that will typically happen is that somebody will send you a letter, right? Say they suffered an injury, and they're claiming that it was a result of participating in your yoga, training, right? They will typically send a letter, letting you know that they're making this claim against you. Sometimes it will be prepared by a lawyer. Sometimes it won't be. They'll just send you a letter directly, letting you know about their injury and letting you know that that they feel that they have a claim against you and are entitled to some type of compensation. And if you have customized specific agreements in place that have kind of preventatively address these issues, then it's a lot easier to kind of go back and point to the areas in the agreements where they disclaimed liability, for any claims against you, in this specific example, right? And you can point to things in these documents that say, no, you actually don't have this, grounds for this claim against me because, refer to the agreement that you signed, when you first started, participating in my services, where you disclaimed, liability. And it can be as simple as that, and can help the issue go away as soon as possible. Because there's really kind of two roads that this can follow once somebody says that they may have a claim against you. And that's the first road, right? Is if you have the customized specific legal documents in place, the safeguards in place, you can go back and refer to those and kind of use those as your first line of defense, right? And use it's a very effective way of solving these issues very quickly, very easily, and at a very minimal amount of time and cost. But if you don't have the documents in place, or you have the wrong documents in place that don't cover you in the way that they should, to be, really in best legal practices, that's kind of the other road of how this can go. And this in this event, you can't respond with the same strong legal position, right? You can't say, hey, refer to the agreement that you signed where you disclaimed liability. I'm actually, you don't have the grounds to bring a claim against me. If you don't have that in place, then your position in responding to them is not as strong. And that's where, you create a very stressful situation, right? Of saying, am I liable to this person? What am I liable to them for? Like, what are the amount of damages they can claim? And, damages can add up very quickly. If someone claims that, as a result of the injury, they've been unable to work, right? And unable to support their family. The amount of monetary damages that they would be, in that event would be claiming could get very high very quickly. So again, just creates a very, very stressful, situation. So really the key is to set up the relationship with the client properly from the start, and having the correct safeguards in place in the form of these legal documents. And because again, as I said earlier, the problems are much harder, much more expensive to fix after the fact. So you want to make sure you have the right safeguards in place in advance. But again, the documents only work, if you have them properly, if you use them, so you want to make sure that the clients are signing the documents, right, and not allow them to participate, in your activities without having signed, the necessary documents. And so you have to use them, right, and B, they have to be properly customized, for your business, to make sure they're covering the specific services that you offer, and that they are really tailored to you and your business, in particular. And that way, that's the only way you can really know for sure and have 100% confidence that the documents, in the event an issue arises, will protect you. So that's kind of the the overview. And now I'll kind of go into the specific documents themselves, and what we really consider the foundational documents, that really practitioners need to have in place in order to be, in best legal practices. And the first, assuming that you are using a website to collect any type of personal information, and or to process payments. But it could be as simple as just collecting first and last names and email addresses, is a privacy policy and terms of service. And this one's simple. It's really just about compliance. There are federal and state, and also international, privacy laws. And these dictate how, you can collect data, what you can do with the data, how you have to store the data, who you can share the data with, and all sorts of things like that. And so very important, just to be in compliance with these laws, to have clearly displayed on your website. Usually, if you go to any big website, you'll scroll down. It's usually at the very bottom. There'll be a link to the terms of service and the privacy policy. Very few people ever click on them, ever read them, but just by displaying them, that you are in compliance, as long as they contain all the information that they need to contain. By displaying them, you're in compliance. So this one's very, very simple, very straightforward. And again, this just protects you against, if there's any an incident of hacking and the data is compromised in any way. You have it outlined in there, and you have everything covered of how you store data, and no one can claim that you that you improperly collected or stored or shared their data with anyone. It's all spelled out in there. So that's the first, really, really foundational, one. That's not something that anyone needs to sign. It's just, display on the website, again, about being in compliance with, with the federal and state privacy laws. California in particular, I know we have a lot of East Coast, people here, Boston based crowd, but California in particular has a very, they're one of the strictest states and has a lot of very state specific things that need to be included in the privacy policies. And they actually made some changes to their privacy laws here, effective January of this year. So this is something that's kind of constantly evolving and can change over time. So that's the first one. The next really foundational document is a media release and social media disclaimer, and it's kind of two parts here. The media release, the purpose of the media release is if you are using anyone's name, image, or likeness, right, in your marketing promotional activities. So if you are displaying their images on your website or using them as part of a marketing campaign, then you need their permission to be able to do so, while also stipulating that you're the owner of the images and they're not entitled to any type of compensation for that. So it's just getting someone's permission to use their image, name, likeness, testimonials, that type of a thing in your marketing activities. So these days reviews and testimonials and all that are such a big part of marketing efforts that it's really important to make sure you have the correct permissions in place to be able to do that, and not be able to have people come back later and say, oh, you can't use my name or my image here, or I'm entitled to compensation for this. So really important to go ahead and have them sign that, releasing their providing you the permission to do so. The other part of this is the social media disclaimer, and this is really important to have on your social media profiles. Somewhere, usually what people will do is put a link tree at the top of the profile, like you say it's Instagram, a link tree. They click on the link tree and there's a link to your social media disclaimer. Or I've seen people put it into a pinned story there at the very top, so it's clearly displayed at the top of the profile. And what this does is it disclaims anyone who is, from a claim of any injury as a result of following your advice that you're giving on social media, right? If you have a social media post that's saying, hey, check out this, yoga pose, this is how you do it. It's great for XYZ. Give it a try, or whatever the case is, and someone does that and suffers any type of an injury, then they can't come back and say, oh, well, as a result of, I have a claim against you because I was injured by following your advice, on social media. So it's a way to disclaim liability for anyone who's following your advice, virtually, not in, in your studio or anything like that, just on social media. So really important to have that displayed, on your social media profiles. The next, and this one is critical, is a liability waiver. So, a liability waiver this is one that can really cost you the most if A, you don't have it, or B, it's not done properly. And the liability waiver basically disclaims liability for somebody to be able to file a claim against you for injuries as a result of, again, participating in your services, right? So this would be somebody who comes into your studio, as a result of participating in your activities, they suffer an injury. And again, goes back to the example I gave, say they can't work for a period of several months, and want to file a claim, against you to compensate them for those damages. Having the correct liability waiver, in place at the very beginning of the relationship, dramatically minimizes, reduces, or eliminates the risk of somebody bringing, a claim against you, for these injuries. So similar to the social media disclaimer, but different in the sense that, this is something that will actually be signed by your clients really from the get-go. It needs to be in place before they ever participate, in your activities, so that that they can't come with any claim for any liability for any injuries or damages that they may claim as a result of participating in your activities. And the last one is, this one's an either or, is a W-2 employee agreement or a 1099 independent contractor agreement. And in rare cases, some business owners might need both, but usually, if you have people working for you, they are either going to be classified, as employees or as independent contractors. And this is really important because to know and to make the correct designation at the beginning of the relationship with these individuals. And there's a lot of tax consequences, involved with this. And if you make the wrong designation, and we've seen this happen where, down the road, a couple years down the road, you've been treating your employee or, the people working for you, not to confuse the terms here, you've been treating them as independent contractors. But they were in reality, legally, they should have been considered employees. So you can be subject to fines and a lot of back taxes in that event, because as the employer, for a true, employer-employee relationship, you are required to make contributions to, to various employment taxes and matches and things like that. So they could go back and say, oh, for this whole, the IRS could go back and say, for this whole period of time, you weren't paying these employment taxes. You were treating them as independent contractors, but they should have been employees, and they can claim back taxes against you and also levy fines. And we've seen, unfortunately, operators, practitioners go out of business because they thought that they had independent contractors. Turns out they should have been employees, and then they just get hit with this massive bill for back taxes and a fine that they couldn't afford to pay. So really important to make sure you have that designation, the correct designation made from the get-go, and knowing whether they are employees or independent contractors. And this really comes down to the level of control that the employing agent, individual is, or entity is exercising over the person working for them, right? So independent contractors, legally, you can't exercise a whole lot of control over what services they perform, how they perform the services, when they perform the services, where, that type of a thing. So this would be most common if you have, just kind of individuals coming in, to teach classes who are kind of separate from your organization. They're just kind of coming in, using the space, teaching classes to your clients, kind of on their own schedule, on their own time, doing it their own way, that type of a thing. But if you have people who are really on set schedules and are, you have certain guidelines in place for the materials they can teach, how they can teach, when they can teach, all that type of thing. So the more control you exercise over the individual, the more likely they are, kind of a sliding scale, the more likely they are to slide onto the employee end, of that scale rather than the independent contractor end. Another very important issue with the independent contractor and employer designation is intellectual property, and who owns the intellectual property that you create, or that is created by the hired individual. And the rule of thumb is that for by default in an employer-employee relationship, the employer automatically owns any intellectual property that's created by the employee while they're in the scope of their employment. So not much of an issue there. The employer by default is going to own the intellectual property. So an intellectual property can be very, very valuable. And by intellectual property, things like the processes, the specific types, the specific programming that you have in place, all of that type of stuff. So it's more than just the logo for the business and the name, and those, I think, are the most common forms of intellectual property that business owners think of, but there's more to it than just that. So you want to make sure as the business owner that you retain ownership, of that, because it can be very, very valuable. with an independent contractor, the default is that the independent contractor owns the intellectual property of anything that they create. But in the IC independent contractor agreement, it can be designated that the business owner retains. There's a work for hire clause that allows the business owner to retain the ownership of the intellectual property. So very, very important to to designate the ownership and retain ownership of the intellectual property. And so that's another really important issue that is covered in the in the independent contractor agreement. And another major issue is non-competes and non-solicitation clauses. When you have people working for you and they're working with your clients, you don't want them going elsewhere and taking your clients with them, right? So these are two kind of separate things. A non-compete clause or a non-compete agreement prevents somebody from working in the same field, in the same industry for a designated amount of time after they stop working for you, right? And those are very difficult to enforce. Courts are hesitant to place limitations on an individual's ability to make a living, right? So especially in the case of part-time instructors, it's not likely to be able to enforce a non-compete saying you can't go work for for another studio right in the same geographic area for a period of a year after after your employment with me ends. A court would probably not uphold that in a lot of cases, just because now that individual doesn't have the ability to work in their profession, to provide for their family, all of that. But a non-solicit prevents that same individual, rather than preventing them from going and working for any other yoga studio in the local area. It just says you can't actively solicit the clients that you work with while you're employed with me, right? So you can't actively try to take clients, poach clients, and take them with you in the event you do go to another studio. And those are much easier to enforce and hold up a lot, more likely to hold up in a court of law versus a true non-compete. So a little bit of a difference there, but those are things that are commonly included in these employee agreements or independent contractor agreements. So those are really the four kind of foundational documents that really every practitioner really needs to have in place. If you don't have employees or independent contractors, then obviously that one doesn't apply. But in the event you have anyone working for you, then it absolutely does. But those are really kind of the foundational documents that really every business owner needs to have in place to really be in best legal practices, and to know that they're covered. They're compliant with federal and state privacy laws. They're covered against any liability claims as a result of someone being injured through participating in their activities or in their services. Anybody following their advice or anything they see on their social media profiles, protected against claims there. And lastly, making sure that the correct employment designation is made, and that you have all of the necessary provisions in those agreements to really specify the nature of the relationship between you and the people who are working for you. So does anybody at that point can open it up for questions if anyone has any questions about those particular agreements, or kind of more anything in general?
Yeah, if you guys have any questions, you can just unmute yourself and jump in. I will also say that after this call, you'll all get, within the next couple days, as soon as I can get it all together, you'll get a replay of this, and in addition to a bunch of resources from Conscious Counsel. So you'll get a yoga bundle, you'll get a link if you want to book a call with Michael, a free call to discuss any particular legal questions you might have pertaining to your business in particular. Yeah, so I'll be sending that out to all of you, and you'll get that in the next day or so. Yeah, so wanted to let you know about that if you have any specific follow-ups, because sometimes it might be real specific to you and your business or your particular class, and you might not want to like throw it out in the group environment, which I totally get. But if anyone has any other questions, just jump on in.
Hi, everyone. My apologies for missing the first couple of minutes. Was trying to just transition out of a work meeting, but my name's Bree. I'm dialing in from Utah. I live in the Salt Lake City area, and joined Pretzel Kids. It's been a couple of months now, but I'm not actively doing any teaching yet, which I hope to change soon. So I do have a question. This all makes a lot of sense to me. I've worked within healthcare, and currently I'm working in children's media, very closely with legal and compliance teams. So like a lot of these documents are very familiar to me. But I do have a question. I know that through Pretzel Kids, there's an opportunity to have insurance coverage. So I'm curious, what insurance often will cover for somebody who's teaching, and then if it includes any of these documents, just kind of wondering what some of the differences are between having insurance coverage and then making sure you have these documents, if that makes sense.
No, absolutely. It's a great question, because I think a lot of times, insurance is so important, right? In today's, world, when there's so much risk and liability. But a lot of times I think people make the mistake of thinking, oh, well, I have insurance, I'm covered. Right. And if anyone's ever tried to make an insurance claim, right, whether it's an auto insurance or home insurance or whatever the case may be, oftentimes you'll find out after the fact that for whatever reason, the specific thing that happened to you wasn't covered by your policy. Right. So there can be a lot of surprises when it comes to insurance. There can also be a lot of headaches dealing with insurance. Not saying obviously not to get insurance, but to rely on it as the only line of defense, is really not in best legal practices, right? So where these documents come into play is being your first line of defense, to prevent a claim from being able to be brought against you in the first place. So it's kind of that first, level of defense, and hey, you don't even have grounds to bring this claim, and it can make the problem go away very, very quickly. In the event anything gets through that first line of defense, that's kind of where insurance comes into play in order to, to cover you for any monetary damages you may be held liable for. But obviously the goal is, and the purpose of these documents is to avoid that in the first place. That's a great question, though, because I get that a lot, and it's a very common question. So
great, thank you.
Yeah, and as Robin mentioned, everyone will receive some information from us via a free legal checklist, so you can kind of go through, and there's going to be the documents that I just went through, and some others as well. Kind of go through, see where you're at, and where you feel like you're covered, where you feel like you might not be. Highly urge you to book a call with me. We can dive in. It's a free call, and we can kind of assess your needs, where you're at, where you see your business going, any questions that you might have about what you need, to be in best legal practices. We love, working with new clients, with the Pretzel Kids community. And, I would really love the opportunity to kind of help you assess your situation of where you're at, and where you really need to be, and to help get you there. Just a little bit about kind of our process, how we work. It always starts with that free consultation call, right? Where we'll go in, we'll analyze, where you're at, and where we, advise that you need to be, and see how close we are there, or what gaps and what holes might need to be filled. Working with us, we provide all of these documents and more, right? So that there's additional things I didn't cover on this call that are maybe relevant to someone's particular situation. And so a whole slew of documents that for basically any situation that can be that can be custom tailored, to you and your business. All of our documents we write them, like I said in the beginning, in plain English, for simplicity, purposes, making sure that everyone understands the documents, that the agreements that they're entering into, just to limit any potential for misinterpretation. Also encourage you to, check us out on Google. We have, we're just celebrating a milestone of 355 5-star Google reviews, something we're very proud of. And, really our biggest priority, as a team is, providing 5-star level of service to all of our clients. So, kind of read through the reviews and see, what people are saying about working with us and our process and everything. And we promise every new client that they'll have the same experience as well. Also wanted to mention that for the participants of this call, we are offering, a special discount. If you book a call with me and, we go through and we decide, hey, yes, you do need these 4 legal documents or any grouping of 4 legal documents. The normal base price is $32.88. But for any participants of this call, we're offering it for $28.88. And a little bit what's included with that. We offer, it's a one-time investment. There's no retainer for, working with us on an ongoing basis or anything like that. We provide unlimited edits and revisions of your documents. So our job is not done until you feel 100% confident and satisfied with the documents, and you feel totally comfortable and supported. And then from that point, we provide 3 months of ongoing service, ongoing support on an unlimited basis. If you ever need to call, text, email, hop on a Zoom call, whatever the case may be, with any questions, we're totally at your disposal for that period of 3 months to help make sure that you're comfortable, getting your new documents in place and using them, and you feel totally supported.
Thank you so much. Did someone else have a question? Sorry.
Oh, no, I was just saying that's great. Thank you.
Yeah.
Absolutely.
I will also say that I think all the remaining people here live are part of Pretzel Kids in some capacity. And I will say we have a lot of resources for you as well, business resources, legal resources. So just for being a member of Pretzel Kids. So feel free to make sure you look at all of those. They're all in Circle and in your PKTA course. And then if you have any specific questions on any of that, you can reach out to me. Pretzel Kids has a resident lawyer on staff, happens to be my husband, but he is a corporate trademark attorney and specializes in intellectual property and all of this, which is one of the reasons I like to do this type of workshop, because I know how important it is and how neglected these type of documents can be in the yoga community and how important they are. So I hope you guys found this really helpful.
And one quick follow-up on that, the trademarks and intellectual property, very, very important. We've seen instances where people have been forced to change the name of their business because they didn't file for a trademark, and someone else came in and started using the same name, filed for a trademark. And it doesn't matter who started using the name first, it matters who filed for the trademark first. So, it's one of the most valuable things you have as a business is your name and logo and your brand recognition. So strongly, encourage you to talk to Robin about that. And, if that's not something you currently have in place, it's very, very important to do so.
Yeah, absolutely. We'll probably do a whole other workshop on that because I really feel it's so important. And the other thing is we'll talk to you a little bit more if you want to know how to best use, as Pretzel Kids members, the Pretzel Kids marks, logos, all of our branding, which you guys legally have access to. So I can talk to you a little bit about that too, but so much. I mean, we could be here forever, Michael, but we have to wrap up. So, so thank you guys all so much for being here, and look for a follow-up from me with all the information that Michael discussed. And you'll have his contact information too, if you want to reach out to Michael directly or book a call.
Absolutely. Thanks everyone for your time. It's really, really great to be here with you today. And, I look forward to speaking with you again soon.
Thanks,
Thank
Michael.
you guys.
Bye, friends.
Bye.
Take care.
Thanks everyone. Bye.